Edith Broughton versus Brinker International, Brinker, Texas, and Chili's.
Good afternoon, Your Honor. This is Patrick Wolf on behalf of the plaintiff, Ms. Broughton.
Good afternoon, Your Honor. This is Eduardo Ortiz, and I have my associate Christina Hansen with me as well. We represent the defendants.
Thank you. So, um, we're here at docket call. We're docket call for the Monday, June 22nd jury trials. One of you have brought the continuance motion from that trial. Which one?
Plaintiff, Your Honor, my client.
So Mr. Wolf will be making his motion for continuance, and then I'll hear a response from Mr. Ortiz, and the court will do its best to make a ruling. You may proceed.
Thank you, Your Honor. Before I get into the details of the motion, I just want to note for the court that this would be the first disputed continuance in the case. This would be the second continuance overall. The prior one, the parties agreed in order to mediate, but this would be the first disputed one granted. Also, the case is only a year and 7 months old, so it's not a very old case. I think that favors continuance in this case as well. Plaintiff has 3 reasons for requesting continuance. I'll talk briefly about them, but I think it's important to keep in mind as I go through them that each of these relate to plaintiff's need for discovery in the case, and the need to conduct that discovery did not arise or was not known until after the discovery deadline had passed. The first reason, Your Honor, is plaintiff needs to schedule and conduct expert trial depositions in lieu of live testimony.
This could be the biggest moment of the hearing. The plaintiff says the defense turned over a document just days before trial that allegedly shows someone else was injured in the same area months earlier. If that's true, it could become key evidence because it may suggest the restaurant knew about the hazard before this lawsuit was ever filed. The defense, however, says it was an honest late discovery, not an intentional cover-up.
Trial was originally scheduled, I think, for sometime a couple of months ago before the first continuance was granted. We had all of our experts lined up, ready to go live. That got moved to the June 22nd, next Monday. And we reached out to our experts to confer about their availability for the new date. And unfortunately, three of the non-retained experts are not available at that time. One of them is on her honeymoon for 2 weeks. Another is and the only ER doctor on call for a few of those days at the hospital. So obviously that'd be a medical emergency requiring him to come in. And yeah, so essentially we can't have a few of them testify live. So we're going to need to do trial depots. Unfortunately, the defendants are not participating or cooperating in that process. They're refusing to allow those to occur. In their response to our motion indicates that the reason for doing so is that they're untimely. They're after the discovery deadline. We've tried to just even unilaterally notice one, but they quashed it immediately. So they're not playing ball at all. They're not letting us take any of these depots. The second issue, Your Honor, is that there's an outstanding discovery order that still needs to be entered. There's a pending discovery dispute between the parties. That we had a hearing on that a couple weeks ago, and Judge Mazzi, who oversaw that hearing, offered an alternative relief than what was requested and required the parties to collaborate and submit a proposed order. That order was supposed to be submitted on June 1st. The finalized joint agreed version of the proposed order was supposed to be submitted on June 1st. Unfortunately, defendants, despite my repeated communication with Mr. Ortiz, their counsel did not even send over a draft, let alone the final version, not even a draft over to us until June 4th, 3 days after the court's deadline to get it to the court. And unfortunately, even what they did send over is frankly not at all what the judge requested and ruled. So now there's going to have to be additional motion practice. We're probably going to have to, have an additional hearing in front of Judge Mazzi to clarify what she wanted in the order, and that's not going to happen by Monday. Unfortunately, we're going to have to do a motion, schedule a hearing, have the hearing, get clarification on an order, and then have the defendants comply with that order. That's not happening in a week. The last reason, Your Honor, and frankly, I think the most pressing one, the most egregious, is that I think 4 or 5 business days ago, 13 days before trial, the defendants produced an additional, never before seen 200 pages of documents. They identified a brand new individual who conducted surveillance on the plaintiff. And I think most important of all, one of those documents is probably the most damning piece of evidence that's been produced in this case to date. It's a report that essentially shows the defendants knew about the hazardous condition at their restaurant for at least several months before the plaintiff's accident occurred. And it shows that an individual suffered an injury in the exact same manner, and it seems to be the exact same location as the plaintiff did. Given that that was produced only 13 days before trial, plaintiff is going to need to conduct additional discovery. We're probably going to need to figure out who this individual in this report is and conduct a deposition or do an interview. And we're probably, unfortunately, going to need to do a motion to compel additional documents and possibly a motion for sanctions against defense for withholding this document despite representing to the court for over a year that it did not exist, and then producing it 13 days before trial. Those motions in that deposition, it's probably not going to happen before Monday, Your Honor. Lastly, last point, very quick, Your Honor. The defendants announced for 8 days. If this is going to go 8 days, we unfortunately have a federal trial on the 29th. So we have a conflict there. That's not, I think that one's going to go. I don't think that's going to get moved. So that is another small issue on the side. That's all I have for now, Your Honor.
Thank you, Mr. Ortiz.
Thank you, Your Honor. May it please the court. I'll take these issues up in the same order that Mr. Wolf brought them up. So first is the first time plaintiff ever sought to conduct these depositions was about a month ago. At no point before that did they ever indicate that they planned to call these people to trial or plan to call to depose them. The discovery period in this case concluded February 27th, 2026. So since that time, they've never sought to present them. They've never sought to depose them. We offered to plaintiff's counsel initially requested to depose one of their experts, and we said we would be happy to work with them on that on a different day than requested, if we could also take either trial deposition of one of our experts or present them by Zoom. And then in response to that, they said that they wanted to also take 2 additional experts, and unless we agreed to that, they would be opposed to our motion to for leave to present our out-of-state expert by Zoom. So we never agreed to take 3 non-treating physicians expert depositions within the 1 month before trial, well past the discovery period. Second is Mr. Wolf is claiming that there is an order that needs to be signed by the judge. That is correct. The judge has not signed it yet, but we have satisfied exactly what the court ordered us to do. So for context, this order relates to a motion to enforce that plaintiff filed.
Now you're hearing two completely different versions of the same story. The defense argues they immediately disclosed the document once it was found and insists there are no other hidden records. The plaintiff believes the late disclosure unfairly changed the case just days before trial. That's exactly the kind of dispute judges often have to resolve before a jury ever hears the evidence.
I don't recall the exact date, but it was heard May 29th. Plaintiffs sought the production of about 8 categories of documents that were not responsive to earlier discovery requests. Judge Mousy completely denied all of their relief. They said, I am not going to order the defendants to produce anything above and beyond what was requested in discovery, but I will ask them to provide affidavits indicating they performed a diligent search for materials and that none have been found, or if some were found, to produce them. And we did exactly that. Before plaintiff even filed their motion for continuance, I gave Mr. Wolf the affidavits that were ordered. They say that they performed a diligent search for materials. In speaking to one of our witnesses during during trial preparation, I discovered that there was a responsive document that hadn't been produced previously, and that's what Mr. Wolf was referring to. So we produced that immediately once my client discovered it. And that document is a one-page incident report showing another guest slipped in the same general area as the plaintiff in this case. Earlier on in this case, there was a witness who was deposed saying she recalls there being a slip in this area, doesn't know whether there were any records related to it. Well, this is that record. So there's no additional deposition that needs to happen because they already asked that witness everything that they know about this prior incident, and they have the document reflecting that the incident occurred. There are no other documents that are related to this prior incident. And lastly, plaintiff asserts that we have produced about 200 pages of records within the last 2 weeks or so, or last week. That shouldn't be a basis for continuance at all. The trial court judge can decide whether to allow us to use those documents in trial or not. It shouldn't serve as a basis to continue the case. And one of those, a portion of those records simply relate to a supplemental expert report that our expert prepared, rebutting affidavits that were produced by plaintiff in the last 30 days. So there's nothing in this case that merits continuing the case, because all the trial judge can make rulings on these issues and whether to allow these documents in evidence.
All right. Well, here's where I am. I mean, I'm going to be honest with you. I haven't granted a lot of continuances because the legislature has really, they're making us report them. But this one to me, partly y'all took line number 121. You're not going to get reached anyway. And just the impracticality of having this stick around at standby 6 all week is really playing into my head. I just don't think you're going to get reached. If you were like a 2 or 3 day car wreck trial, I might keep you around because then we can fit you in. But frankly, you need 8 days, and there's just no world in which on Friday of next week somebody's going to be available 8 days. It's just not going to happen. So part of me is going to burn one of my continuances on this case and just do the pragmatic thing and just grant the continuance, which is going to help you, Mr. Ortiz, because now a continuance has been granted. And so we won't do another one, hopefully. We'll get this one tried. I'm not inclined to grant any extensions of deadlines or any additional like pushing away. I'm going to take you at your word, Mr. Wolf, that you have some experts that weren't available and we need to find some dates when they are available. And perhaps we can work out some of these other small issues. But I don't see any big reasons why we can't go to trial pretty quickly. But I'm going to grant the motion for continuance. If we want to put some urgency to it, we could say it needs to get reset before October 31st.
That works for the defense, Your Honor.
I'll have to check with lead counsel, my head partner.
Well, it's not really an offer. I'm actually going to say I'm granting the continuance, but it needs to get reset and on the docket before October 31st. The only reason I'm not putting a date on there is because I know there are lawyers and experts, and I don't want to do the same thing again where we end up with another scheduling crunch, but we got to figure out a date we're available on some jury docket before October 31st.
Understood.
Okay,
Thank you, Anna.
thank you. You're all
Thank-
excused. We can go off the record.
In the end, the judge granted the continuance, but not because he believed either side had won the argument. Instead, he pointed to a practical problem. An 8-day trial simply wasn't likely to be reached on the current docket. The case will now move to a new trial date before October, giving both sides time to resolve the remaining discovery issues and prepare for what could be a closely contested trial. If you enjoyed this courtroom breakdown, hit that like button, share your thoughts in the comments, and subscribe for more real courtroom drama and legal analysis.